Special warm welcome and a very warm welcome, especially to our chief guest, Mr. Jawad, who's going to be talking to us about the new Mediation Act. Mr. Jawad doesn't really need an introduction, I think, in the mediation family. He's been one of the pioneers of mediation for the last nearly 20 decades. So, for the last nearly 20 years, for about 2 decades now. He was, in fact, one of the pioneers for setting up the first mediation center in Chennai in 2005, which was followed by the Mediation Center in 2006. Uh, with his vast knowledge and experience of mediation and the practical knowledge of mediation, because he stopped practicing as actively as an advocate and now he's a full-time mediator. I'm sure he would be able to give us a lot of insights. So, without much ado, over to Jawad for an introduction on the Act. And after that, we would just have a discussion on the Act and it would be open to the floor to ask further questions. Over to you, Jawad.
Thank you. Thank you very much, Shireen. Just one small correction. I was not instrumental in setting up the Tamil Nadu Mediation Center. That was done by the real pioneers. We are all the followers of those pioneers. So just to
The
clarify.
second generation. The second generation.
Yeah, we just followed them a year later into the mediation field.
Mr. Sriram Panchu, I was one of the
Yes, he was the pioneer.
Right.
And
Right.
the late Niranjan Bhatt, all these people have been, they have made a human contribution to the growth of mediation. So anyway, coming back to what we are here to discuss, first of all, I'm very grateful to Nivaaran for this opportunity. And I just want to just give a brief, outline of what the Act is all about. And then we can proceed into the question and answers. I think that would be better so that we can have more of a discussion on it rather than me taking up all the time talking about the Act. Because I'm sure everybody would have gone through the Act and perhaps some articles also have been written on it. So basically, I think one of the things that I always feel very paradoxical is that mediation is supposed to take people out of the tyranny of laws, but the fact that we need a law to give it legitimacy is a sort of a paradox because the law, because we are governed by the rule of law, therefore the law actually confers the legitimacy and the gravitas on the process itself. And therefore, it is something which everyone was really looking forward to, and it came a little late, but it came nevertheless. So we are all very happy about the fact that today we have a legislation on mediation. Now, if you see the objectives of the Mediation Act, basically it talks about. I made a list of about 6 objectives from what I could gather from the objectives mentioned there. One is to promote and facilitate mediation, which of course covers in its ambit both international mediation and domestic mediation. To promote institutional mediation, which is very important. To enforce the mediated settlement agreements, because that is what was actually lacking so far without the law in place. What is the effect of a mediated settlement agreement? Is it merely a contract, or is it something that has some, binding force in the sense that you can simply go and execute it? So this question was always worrisome, and we used to take recourse to the Arbitration and Conciliation Act and call all mediations, that is, I'm talking about the private mediations, we used to call them as conciliations, and we used to go under section 74 of the Arbitration and Conciliation Act to give a binding effect to settlement agreements that were reached. The fourth point that the Act talks about is to establish a regulatory body, which is in the form of the Mediation Council. And the fifth is to encourage community mediation. Because, in our country, we have the panchayat system, which we call as mediation, but in strict sense, it is not mediation because there is a coercive element which is involved in that. Because the decision of the panchas invariably has to be obeyed by the disputants, and if they don't obey that, some kind of penalty or the other, including social ostracization, follows. So, but community mediation as such has been taking place very informally. throughout India, but today it has a statutory, basis. The sixth point is the online mediation to make online mediation an acceptable and cost-effective method. So the objectives are very laudable. Now, how far the Act goes forward to achieve those objectives, we'll have to see by examining each of the how the Act covers these matters. So, for example, if you take domestic mediation, one of the most important, or rather two of the most important things are, one, the institutionalization of mediation, because the Act recognizes two kinds of institutions. One, the mediation service providers, and the other, the mediation institutes. So one is basically, as the nomenclature says, it's a service provider. So you have a panel of mediators, and you offer the service of mediation to clients who approach you. Mediation institutes basically are responsible for conducting training of mediators. Now, one peculiar thing about the Act is, while it empowers the mediation service providers to accredit their mediators, similar power is not given to the mediation institutions that train the mediators. So there is some contradiction over there. But what should have been done, actually, in my opinion, is the mediation council should be given the power of accreditation. Because, I cannot have my own panel and I cannot say that I have accredited these mediators. Or I cannot train my own mediators and say I have, accredited these mediators. There have to be, independent accreditation standards, and that should be done by a centralized body like the Mediation Council. But perhaps in the course of the working of the Act, all these changes will come about. The other thing is, of course, as I earlier said, the enforcement of the mediated settlement agreement. So the Act confers the status of a decree of court on a mediated settlement agreement. So those are the two things that are very good about the Act. Insofar as domestic mediations are concerned, we'll go into the lacunae that are there. A few lacunae are there with reference to the how this is going to work out. In terms of challenging the mediated settlement agreement, in terms of the exclusion of the period of limitation. All these are points that we need to be discussing on. Now, coming to international mediation, one very disappointing thing about the Act is, though India was one of the first countries to sign the Singapore Convention in 2019, the Act doesn't speak about it at all. There is no reference to the Singapore Convention. And when it defines mediation, what it does is it includes international mediation also. If you see section 2(3), subclause 3, section 2, that if it applies to the applicability of the Act is also to international mediations. Now, international mediations are, of course, defined a little later under section 3. But the drawback is this, that if international mediations are coming under the purview of the Act, and if a mediated settlement agreement is regarded as a decree of the court, then does it take it out of the purview of the Singapore Convention? Because the Singapore Convention specifically excludes any mediated settlement agreement that can be executed as a court decree. So anything that is executable in a court of law is excluded by the Singapore Convention. So does this effectively take out international mediations from the purview of the Singapore Convention is a question that arises for consideration. Apart from that, there are many other provisions of the Act beg a little revision at a later point of time. Now, one of the biggest things where we see some problem that may come up is the composition of the Mediation Council. Now, normally, any professional body, whether you take the Bar Council or the Medical Council or the Institute of Chartered Accountants, all these are all self-regulatory bodies, and mostly the professionals who practice that profession, actually run these regulatory bodies and frame the rules and have the disciplinary mechanisms and all that. But for some reason, I don't know why the Mediation Council is more of a kind of a bureaucratic setup. manned by people who are going to be appointed, not elected. Because normally in professional regulatory bodies like the Bar Council, we have elections. But here there is no provision for elections, and most of these are appointments that are made by the central government. So this is briefly just a summary of what the Act is all about. So now I would like you to go ahead with the questions and answers, and I will try my best to answer. We have a lot of senior advocates here. I'm sure all of you would have gone through the Act. So this is whatever I'm going to be expressing are, the disclaimer is that these are my points of view. Open to contradiction, open to discussion. Okay.
Thank you so much, Jawad, for that introduction. Jawad, for a start, would you like to just tell us what is the difference between the existing regime and with the coming of the new act? What has changed practically and possibly, at least, it seems like it has changed.
See, there are two things, Shri. One is every statute that talks about dispute resolution, that is alternate dispute resolution mechanisms. For example, you take Section 89, you take of the CPC, you take the Companies Act provisions, you take the Consumer Act provisions. They all talk about the courts referring these matters to mediation or conciliation. Now, these two processes are used disjunctively as two independent processes. Now, one of the most significant changes that the Act has brought about, it has conflated all these definitions into one definition and has called it as mediation. So we don't have something called conciliation, which exists separately now. And the various schedules are carrying out those amendments to the various statutes where these are referred to in two different ways, as mediation and conciliation. So number one is that confusion has been done away with. Is there such a thing called conciliation? Is there such a thing called mediation? Are these two different? Now, there was a distinction earlier that people were trying to make. Now, what used to happen was, now, as a result of this, because there was no separate law governing mediation as such. So therefore, what used to happen was that only the matters referred by the courts for mediation specifically, by calling it as a referral to mediation, there alone, you would call the process as a mediation process. Now, what would happen is you do the mediation, and if you reach an agreement, it would go back to the court.
Right.
So that was the prevailing situation then.
Right.
But today, there is no need for that. Of course, matters which are referred by the court will, of course, go back to the court even now.
Right.
But the possibility of doing a mediation independent of the court also is now possible, because mediation as a process is statutorily recognized today as an independent process. And the agreement that you reach in a mediation, which is called the mediated settlement agreement, has the force of a decree of the court. So it is executable. So there is an element of finality that is given to the process. Now, earlier, as I had pointed out earlier also, what we used to do was, where pre-litigation mediation was concerned, except under the Commercial Courts Act. Now, that has its own issues, which, if time permits, we may perhaps discuss it. But what we used to do was, even pre-litigation, if parties come to you for a mediation, you don't call it a mediation, you used to call it as a conciliation.
Right.
Okay. Now, the process of conciliation, as described under Part 3 of the Arbitration Conciliation Act, is a little more proactive as compared to the conventional idea of facilitative mediation that we understand. Because where the mediator refrains from offering any settlement or a framework for a settlement to the parties. So leaves it to the parties to come forward with their terms of settlement. But in a conciliation under Part 3, a mediator can be proactive, can frame the terms of settlement and give them to the parties for consideration. So these were the distinctions which have now been removed by the coming of the Mediation Act. So those amendments have been carried out under the various schedules. Mediation is regarded as, that is the only nomenclature that is provided. So as Shakespeare said, a rose smelling as sweet by whatever name. So you may call it anything, but it is ultimately mediation, and it comes under the Mediation Act.
So you're right, Jawad, in saying that we have used the word now interchangeably,
Yes.
mediation and conciliation, which is in fact the international practice. And even UNCITRAL is the one which suggests that, these are to be used interchangeably. But I just wanted to understand, under Schedule 6, does it have an impact on, in fact, does it amount to a repeal of the entire Part 3 of the Arbitration and Conciliation Act? Or does that Part 3 still remain? Because it does not specifically say so. And would it further, if I can just go ahead further, mean that whatever are the grounds of challenge for a conciliation, which was actually Section 34 of the 1996 Act, would they still remain, or would it now be the grounds of challenge would be under 28 of the new Act?
See, if let us just check out what Schedule 6
Right.
says.
What is the summary of part 1 of this page?
Sorry,
Somebody said something?
I'd heard someone. Someone wants to
Yeah.
just say something in? Okay, go ahead, Jawad. So
Yeah.
let's have a look at Schedule 6.
See, if you see the amendments that are made
Right,
in the Arbitration Conciliation Act, in Section 43D, in
right,
subsection 1, the words mediation, conciliation shall be omitted.
right,
In subsection 2, in clauses E, F, and I, the words and conciliation, wherever they occur, shall be omitted.
right,
Okay. And for section 61 to 81, the following sections shall be substituted. So now,
right,
wherever there is a reference to mediation, conciliation, that has been changed to mean only mediation. Okay.
right.
Now, as far as part 3 starts with section 61, actually, if you see.
Exactly.
Because 43D comes earlier.
Right,
So, reference of conciliation in enactments, any provision in any other enactment for the time being in force, providing for resolution of disputes through conciliation, in accordance with the provisions of this Act, shall be construed as reference to mediation as provided under the Mediation Act 2023. Conciliation as provided under this Act and the Code of Civil Procedure shall be construed as mediation referred to in Clause H of the Section 3 of Mediation Act. Saving, notwithstanding anything contained in Section 61, any conciliation proceeding initiated in pursuance to Section 61 to 81. So virtually, if you see, though there is no word saying expressly,
specific.
there is an implied repeal of these provisions.
Section 61 to 81, which
Yeah,
is the one
because
which dealt with conciliation.
yeah. So even
So
if
if
you go for a conciliation under Part 3, it will only be a mediation under the Act of 2023.
right.
So there
Thank you.
is, in my opinion, there is an implied repeal of Part 3.
Thank you so much for the clarification, Jawad. Jawad, also the 9th of October 2023, I'm sure is a day which is etched in your mind because you've been working so hard on it and the mind of a lot of mediators. However, on that day, there are only certain provisions which have come into force. The act was published and received the assent of the president in September, on the 15th of September last year. And some parts of it came into force on the 9th of October, but not all of them. Would you like to, comment on the provisions that you hope will be implemented at the earliest?
See, my understanding, correct, I may be wrong on this. My understanding is that perhaps the entire Act will be notified once the council is constituted and the rules are framed. Okay, it's only
Right.
because of that only one part of the Act has been notified. Now, I really cannot substitute my wisdom to the wisdom of the government and see why this has been done in this manner. But the fact is that only certain provisions have been notified and certain the remaining Act is still to be notified. So I think perhaps the entire Act will come into force once the Mediation Council is constituted by the government and the rules also come in place. So because there are, there are regulations to be framed
Right.
for the Mediation Council to carry on its functioning.
Right.
So once that is done, I think probably perhaps we can expect the entire Act to be notified.
In fact, would you say that the act is not really effective as of now? Because, some of the important clauses haven't really come into effect, especially as you mentioned, the council has not yet been set up. So, how effective really is the new act as of now?
See, if you look at it from the perspective of the mediation service providers and mediation institutes that the Act talks about, if you look at it from the perspective of the institutional mediation, now there, the problem will be, the problem as of now is that what is the standing of the MSPs and MIs that are functioning today?
Right.
Okay, because they continue to function as they used to do even before the Act came into force, right?
Yeah.
So that is how they continue to function. Now, what will happen is once the mediation council comes into effect, they will get the statutory recognition that they actually deserve under the Mediation Act. So this is the only change perhaps that is going to come once the council is notified. That is my understanding. I may be wrong here, Shirin, but
Right.
I look at it.
Right.
Yeah.
So I think that's right. And the other thing is, as far as accreditation is concerned, hopefully that will be more streamlined,
Yes.
once that is done. And it will also help all the other stakeholders, and especially the people who want to resort to mediation, if they know that, there is a valid accreditation. I think that would be very essential in doing it.
Exactly.
Also, with regard to training, mediation training, like you mentioned that we have these two separate institutes for mediation training. How much of it would be recognized? So, do you think it's the council who would be recognizing the training as well as the accreditation, or not really clear as of now?
See, the Act says that a mediation service provider can accredit mediators. Okay.
Right.
So supposing I have an organization which is a mediation service provider and I have a panel of mediators, I can accredit those mediators and say that they are mediators accredited by me. Now, as to what is the legal sanctity of that accreditation without the council giving its imprimatur to such a recognition is a question. Okay, that we need to ask. So once the council comes into force and into existence, and the council says that yes, this is a registered mediation service provider, then my accreditation of my mediators would have a legal sanctity also, a statutory basis. Okay.
Right.
Now,
And I guess,
yeah.
sorry.
Yeah, go ahead, Shini.
No, I was just saying, and I guess the council is going to lay down rules on recognition of MSPs, because that is going to be very important as to what is going to be the criteria for recognizing mediation institutes and
Yes.
also recognizing mediation service providers. That's, I think, that's going to control the
See,
quality.
there are many things now, because, for example, if you talk about mediation training as such, okay, we have a 40-hour training module that we follow. MCPC follows that. Mediation Conciliation Project Committee of the Supreme Court, they follow that. Almost every other institution follows that, and it is globally come to become the standard for the training of mediators. So you need to undergo that 40 or 50 hours training to get accredited as a mediator with IMI or with CINI or any of these international organizations. So is the Act going to say, is the Mediation Council going to say that yes, 40 hours is the valid training that you need to undergo before you can call yourself as a mediator? Because it is not only mediation service providers that are going to be registered with the council. Even the mediators, individual mediators can get registered with the council.
Right.
So what is the qualification of those mediators? That we can know only when the regulations come into force.
Right.
So
Right.
as of now, what we are doing is we are getting trained as mediators by undergoing the 40 hours in the hope that this will be recognized by the mediation council. And I don't see any reason why the council will differ on this, because that is the globally accepted norm for mediation training. So probably the council will also say that if you have undergone this 40 hours training with a recognized institution, then you will be accredited as a mediator.
One very interesting story which I heard, Jawad, how did this concept of 40-hour training is sufficient come up? So I believe that the first time that this training was held, you possibly heard this story. So I believe that the story goes that they got a deal with the hotel for 40 hours. And that's the reason why we have this 40-hour training. Is that true?
No, actually, this is what I had also heard, because Uma Ramanathan had read it somewhere, and she told us.
So that's
And
very
so
interesting.
we
I
got
mean,
to know
that's the
that.
only reason why we have this
Yeah,
40-hour,
yeah.
which is so sacrosanct
Exactly.
across nations.
Yes,
It's,
yes.
internationally accepted. And only
Yeah.
because some hotel gave them a deal for 40 hours.
Correct.
So yes, that's one of it. Okay, one of the other things which has, if you look at section 6, it gives you the areas which cannot be mediated,
Yes.
which includes criminal disputes. One of the interesting things which is included in the schedule, because this is to be read with Schedule 1, is disputes which are before the TDSAT, which is the Telecom Dispute Settlement Appellate Tribunal. I'm a part of the TDSAT, and until recently, especially during the tenure of Justice Sinha, there were many disputes which were settled before the TDSAT. So I don't understand, as to why do we have this as an exclusionary clause? Any takes on that?
See, we have all had some concerns with the first schedule. Okay. And the first schedule, as it earlier stood, even included fraud. Cases of fraud cannot be mediated. Now, when you talk about criminal cases or when you talk about fraud, of course, that has been removed now, fortunately. But I think that was one of the objections that Mr. Panchu had also raised very strongly before the Parliamentary Standing Committee, saying that cases of fraud can be mediated. So there's no reason to exclude them. So perhaps on account of that, the Parliamentary Committee recommended that that be excluded. So I mean that is the cases covered. That is cases vitiated by fraud can be mediated as
Right.
assumed from the Act now. But these what Section 6 also says is that these cases can also be mediated, but the only thing is they will not have the effect of the settlement
Decree.
agreement will not have the effect of a decree of the court.
Right.
That is what Section 6 says. So they can be mediated.
Right.
But the only thing is whether it can be enforceable. Is it executable or not? The settlement agreement is a question. So for some reason, even if you see community mediation also, a settlement agreement reached in a community mediation cannot be executed like a decree of the court.
Right.
So what is the reason for that is up for conjecture. Perhaps one of the reasons that I can think of is that the court, because given the inherent issues that come up with such mediations. For example, if you're mediating a domestic violence case, or if you're mediating a 498A case, or if there's a community mediation of some kind of an oppression of some marginalized community, some agreement is reached. Now, what is the sanctity of that agreement in the sense that, yes, it is an agreement, but its objective is only to maintain the peace. But whether that can be enforced if anybody, breaches that agreement is a question. Because if supposing, let's say that somebody from a weaker community or a weaker section of society gives an undertaking, we don't know whether it is an undertaking given voluntarily or not, because
Right.
there
Maybe
are
under
a lot
pressure.
of questions that come up. So perhaps that is one reason why the legislature in its infinite wisdom thought that, we should not make these enforceable settlement agreements. But the basic objective is to maintain peace and harmony. So in the case of community mediations. And in the case of the first schedule cases that are listed, there are many cases which operate more as rights in rem because, offenses that affect the state.
Against the state.
Yeah,
Right.
so all these things are there. So
Right.
sometimes it affects the revenue of the state. There are so many issues that are involved in that. Now, can these be mediated is a question that would have worried the government. And they would have thought that, okay, let us allow the mediation to happen if in case there is a possibility, but it will not be an enforceable or an executable agreement that will be entered.
So in fact, Jawad, this section 6 read with the first schedule has not yet come into force.
Yeah, it
So
has not come.
possibly there is some rethink going on. Is there any committee that has been, actively looking into it still?
No, I understand that there is some committee that is framing the rules, but I really, I don't have any authentic information about that.
Right. Right. The other thing is, is there any difference on the items which are included in list 1, excluded from mediation compared to the existing common law practice? Is there anything like one of them which I mentioned I know of is TDSAT, but anything else that which has been, because it seems to be a very wide exclusion. Does it seem to be wider than the existing practice? the
I
exclusionary clause?
don't think it is, I mean, it has specifically mentioned some statutes. Other than that, I don't think the scope is as wide as, wider than what is actually shown there or what was actually happening over there. But, as Mr. Gaurav Kohli has pointed out in the chat, we do mediate cases. Like, for instance, yesterday I was mediating one dispute, which was a criminal case where the boy and girl agreed to get married and, they had a physical relationship. Then the boy backed out of that. So the girl filed a complaint, and the reason for his backing out was because she belonged to a lower caste. So this dispute was mediated, and they almost reached a settlement, but there was some issue which could not be resolved between them. So on account of which the mediation could not be completed. But there have been cases like this which have been mediated, but those are all referrals by the court. So the court refers them for mediation, and we mediate those cases. But it ultimately the agreement goes back to the court. So the court gets the opportunity to test the sanctity of the agreement, or whether the parties have entered into voluntarily, or whether this can be legally a valid settlement. So the court gets an opportunity to test all these things. But when we talk about private mediation, the question will be who's going to test those agreements. So that is why it says that you cannot enforce it like a decree of the court.
So in fact, I remember I once asked you, that whether there could be a mediated settlement in favor of a minor, So Schedule 1 specifically says you can't have it against a minor, but if there is some money to be recovered by the minor. So you had suggested that it may be a good idea to just mention a line in the settlement, so that the court can have a look at it to say that there is a minor that is involved in it. And
Correct.
thereafter, it is for the court to take further care of the interest of it, which I think was a good idea. So that it could be done, there. In fact, yesterday I was at the bookshop of the Delhi High Court Library. And what struck me as soon as I entered was that there were a number of books on mediation which were right up their front, which was so good to see. So I think one of the biggest impetus to the mediation advocacy has been the act itself.
Yes.
Would you like to suggest what is there in the act which may be up for advocacy better, and how can we advocate mediation better?
See, actually you don't even need the law to advocate mediation. All you need is common sense. Okay. That's how I look at it. Because, see, I always give this example. Pooja, we'll just come back to you. Just give me a minute.
No worries at all. No worries at all.
So, see, in the good old days, I mean, I don't know whether you can call the good old days. If you go back to the European history, the medieval period, if supposing somebody insults someone or there's a dispute, they will invite each other to a duel. So they go into the park and they have witnesses, and they draw out their swords, and they fight with each other, and whoever wins, that person's honor stands vindicated, or that person's proved to be right. Okay. Now today, that is exactly what we are doing in our courts. And we lawyers have become nothing but glorified gladiators. We don't fight with swords, but we fight with words. So this is what we do, right? Now, my question is, if you and I have an issue, have a dispute, isn't it a basic, fundamental, human, decent thing to do to sit across the table and talk to each other and find a solution for that? Now, that is not without challenges, because you and I might be very angry, we might be upset, we might not look at the issue with a broader perspective. So we bring in somebody who is helping us to go do that. So my question is, why should even mediation be called as an alternate dispute resolution mechanism? Excuse me, sorry, I'm just recovering from a viral infection. So it should be the mainstream dispute resolution mechanism, and adjudicatory methods should be the alternative. So you call the court system as an alternate dispute resolution mechanism. You call the arbitration as alternate dispute resolution mechanism. So the first basic thing that you do is to talk to each other and find a solution. Isn't that, a fundamental commonsensical thing to do? So that is my question. So, of course, now, because we are so obsessed with the legal positivist theory that has been propounded by the British and that was imposed upon us, and we are so obsessed with our court system that we can't think of anything outside that. So therefore, we need a law to even tell us that, okay, sit and talk about this. Okay, if you have a dispute, sit and talk. We need a law to tell us that. So that is the irony of our civilized existence. Okay. So my only question is, uh, if you look at it from that perspective, yes, the act is a boon to that, actually, because it has created an awareness. It has given legitimacy to the process. It is no longer mediation, is no longer the poorer cousin of litigation and arbitration. So like how in, Diwar Shashi Kapoor says, mere paas maa hai. So we can say, no, mere paas bhi law hai. So that is where we stand today. Okay.
Yeah, yeah. I'll come to Pooja first and then, we'll
Yeah.
go ahead with it. Pooja, you had a question or an
No,
observation? Yeah.
yeah, I was just wanting like an honest opinion, like what about this
Your
act
voice is
which
cutting,
has
Pooja. Is it only for me or is it for everybody?
No,
been
even for me,
given to
Pooja's
us,
voice is
but
breaking.
is it? I see my internet is unstable.
Now
Let me
it's
switch.
okay.
Yeah,
Yeah.
now it's better.
Now
Yeah,
we can hear you.
You can hear me good?
Yes.
Otherwise, I would need to change the room.
No,
So what
that's
I'm
perfect.
saying is that we've been given an act, which is, I feel, is like we work day in and out. Jawad sir, you're very well aware that the bill which was sent and what we sent has not been given to us. What we've been given is a, like a lollipop in the name of like, it's like something which has come to us as a charity that, okay, you wanted an act here, you take it. But does it really help us and cover us in the way that we had wanted it to be? Like, for instance, Section 28. Where was the need for that? When we tell the parties that this is a finality and then, like, you're going to fix it forever. There is a challenge procedure which is mentioned in the act. And these days, all litigants are like, and like I always tell that children these days are born graduates. Likewise, when litigants are coming, they're well equipped. And then the lawyers who are accompanying, who are lacking the mediation advocacy, they say, Acha, okay, yahan par decide kar lo, you close this chapter and we'll reopen it under Section 28. So isn't it going to be the multiplicity of litigation? After getting a settlement, also, we're leaving the doors open, I feel.
No, but are you saying that there should not be any procedure for challenging a mediated settlement agreement, even if it is vitiated on the grounds mentioned in the act?
That by itself would be void ab initio. It's something which is like illegal. Things cannot be. Supposing there is something written who hasn't got the domain knowledge, and they say, okay, you will get divorced tomorrow. Is it possible? No, they have to go through the process of first motion, second motion. If it's under the Muslim law, many people, I myself was shocked to see one settlement where the parties were Muslim and the settlement was being written like first motion, second motion. And I was like, what are you doing? There is no first motion, second motion. So those settlements are already void ab initio. But are we not opening a Pandora's box by saying that, all right, here you have, okay, you comfortable, sir?
Yeah, yeah, I'm
That
okay.
you have a way to bypass. You have Section 28(1) helping you. Because if the parties are already in dispute, they will say, okay, I was cheated. The other party did not come across well. Are we somewhere like giving them an opportunity to litigate?
See, the scope
That's
of
what I
28
thought.
is, no, 28 is
My
very, very limited, Pooja, because see, when you're giving the effect of a court decree on a settlement agreement, then there should also be an avenue for the parties to go back on that agreement if it is an agreement that is vitiated by for certain reasons. Because without that mechanism for them to come out of it, then they will be bound by something that they did not really agree to. See, basically a mediated settlement agreement, there has to be a consensus ad item. If that consensus ad item has been vitiated because of lack of information or because of some fraud that has been played by somebody or because of the corruption where some information has been suppressed, now don't you think that party should have the freedom to question that agreement?
So I'm not saying that they should not have, but the very fact that there is this little challenge to a mediation.
But should that not be there in the act? Because if the act gives a certain power to settlement agreement, confers a certain status on it, should the act also not say that such an agreement will be vitiated if these grounds are there?
The scope is large. It is not like, those settlements which are void ab initio can be challenged.
No, on the contrary, I feel that the scope is very narrow. Actually, it's very,
I
very narrow.
So I think it's all very subjective, something like
Yes.
this, but definitely what Jawad is saying, we do need to have certain situations that could arise where it would need to be set aside, if
Yeah.
there is a kind of a fraud that maybe have been committed, if there
Correct.
is any other of those four grounds which are set out in 28, then maybe, or maybe
Let
not,
me
that's of course up for
let
discussion,
me
but there
just
needs to be something.
let me just give you an example. For example, if you and I enter into a mediated settlement agreement with regard to Pooja's property about which Pooja doesn't know at all. Now, that agreement can be executed as a decree of the court without the court knowing that this belongs to Pooja. And if Pooja comes to know, should she not be having the right to challenge that?
And secondly,
would
there may be a third party. You might be mediating a property which, in fact, doesn't belong to either of you. And the
Correct.
court decrees it. So, what about the third party who's an outsider? Can they not challenge the decree saying it's actually my property? How could they have entered into a
where
settlement?
will the challenge lie? Should it lie under the Mediation Act or should we go to another act?
No,
Should
no,
it
it
be
is under the act. That is why that provision is there. It is under the act, and the court that has the jurisdiction also is spelled out over there.
as you
Jawad,
said, primarily okay.
Now
Yeah,
let's go
Shri,
ahead.
thank you.
Let's go ahead.
I
no,
think
no.
those are views which can, be discussed further on. Jawad, what I was just thinking is moving on, for the sake of our varied stakeholders, if you could just tell them, because we have people who may be prospective clients or existing clients, they're students, and we have, of course, senior mediators and all over here. So for the benefit of all of them, if you could just tell us, what do you think are the benefits of mediation per se, specifically under the Act? Including the cost aspect, because there are a lot of them who feel, that this would still be another expensive proposition like arbitration has turned out to be. So, your take on it, please.
Yeah, see, basically, Shireen, what I believe is that, see, where mediation is concerned, the first and foremost features of mediation that really recommends it very strongly is that you retain the control.
Right.
Okay, so you don't let go of the control because it is your dispute. You still have the control either to settle it or not to settle it, or to resolve it in a manner that suits you best. Right?
Right.
Of course, there are many other advantages like, relationships remain intact. They may or may not remain intact, but whatever it might be. But the feature of mediation is that you retain control. That's the most important thing. And the second aspect is that because you retain control, you know when to walk out of it or when to continue with it. Therefore, you have a control not just on the outcome, but also a control on how much money you're going to be spending in terms of paying the mediators or paying the lawyers who are assisting you in the mediation. So, for example, if you find that, if the other party is dragging the issue and doesn't want to resolve quickly, you can always walk out of the process. It gives you that control. Right?
Right.
So,
And
right.
What about the fees of the mediators, etc.? Like they've like for the arbitrators, there have been huge fees, which has become more of a burden than in fact going over to the court. What do you think could be the difficulty with regard to that, since there is nothing that the Act speaks about on an upper limit to the fees, especially where you have private mediation?
No, the fees would be something which may depend on various factors. Okay, we don't have any. See, it is at a very nascent stage today, and all along it has been a court annexed process where it has been mostly pro bono. So we are starting out on something which is very new. So
Right.
ultimately, the market will decide, what would be a reasonable fee to be paid to a mediator depending on the effort. Now, I have had cases where in private mediations where I have done the mediation and initially the lawyers have approached me saying that, look, Jawad, this is all we can pay you for now. But, let's see how it goes. And, then depending on what happens, ultimately, we will discuss the fee. And they have voluntarily come forward and given a fee beyond my expectations also. Okay, so see, ultimately, it's the feel-good factor that you get out of mediation.
That's
People feel
true.
happy because they feel that, okay, we have settled this and we are out of the whole thing. We have a conflict-free future today. So therefore, let's reward the mediator. Okay.
Right.
Now, that depends on how good the parties also are and how
Right.
they're able to bring out that goodness in them throughout the process. Right?
Yeah.
So all these factors are there, but I think ultimately, we may, because see, even under the Arbitration Act, we didn't have a Schedule 4 earlier. Schedule 4 came
Right.
much later, where
Right.
prescribed. So perhaps even here, I think something might get evolved. Maybe the Mediation Council will come forward and fix some fee structure for that, so that it's good for the mediators also.
Right. Right. We,
Jawad sir,
as far as, sorry, carry on.
yeah,
Yeah, Vinny.
I have just a question, Jawad sir. And pre-litigation, as per the Mediation Act 2023, in the Commercial Court Act, Section 12A says that the period of pre-litigation mediation would be 3 months. But as per the time limitation given by Mediation Act 2023, it says it is of 120 days.
Yeah.
For the pre-litigation mediation. And the Act says at the same time, whatever is given as per the Commercial Mediation Act Commercial Court Act, Section 12A, they will follow the same structure. So considering that, I just wanted to know whether in the pre-litigation or Commercial Court Act or commercial mediation, whether we can consider the Commercial Court Act time framing or the Mediation Act 2023 time frame, which is 120. So either it is 120 or either it is 90 days. That is my conclusion, just a small question.
One of the problems with the Act as of now is that there's a lot of confusion with regard to the Commercial Courts Act and the Mediation. Because at one point it says if a dispute is of the specified value and comes under the Commercial Courts Act, the Commercial Courts Act will govern the dispute.
Yeah.
So now if that happens, then of course, if it is going to be under the Commercial Courts Act, then it will have to be the period that is prescribed under the Commercial Courts Act. Now, it's only if it is not coming under the purview of the Commercial Courts Act, if it is something which is not falling within that specified value definition, then in that case, the Mediation Act time period will apply. Okay. But either way, my feeling is that, yes, there is an outer time limit that has been prescribed, but in my humble opinion, I think it is not right to prescribe a time limit, because when you are calling it as a voluntary process, when you're saying that parties have the freedom to, decide on how they want to settle the matter, then you should leave it to the parties to decide what extent of time they will be taking to resolve the dispute. Because sometimes, it may take some time for the parties. Now, why do we have a statutory limit on the time that they spend in trying to settle their matter? See, basically, what is the objective of mediation? It is your problem, you find a settlement for it. Now, why should somebody else come and say that, no, you have to find a settlement for it within this period? So it kind of goes against the spirit of the process. So my personal belief is that there should not have been a time limit either under the Commercial Courts Act or under the mediation. It should be left to the parties to decide, because either way, what happens if one of the parties feels that the matter is getting prolonged and they're not interested, they have the freedom to walk out of it. It is not something like an Arbitration Act where the arbitrator has to render a finding and give an award. Okay, so here you need a time limit. But here there's no need of a time limit, because parties have the freedom to walk out of the process at any time.
Correct. Or also it is on the complexity of the matter. In the commercial cases, big companies involved and the stakeholders involved. So,
see, for example, we have in the court annex mediation, we have 60 days plus 30 days.
Yeah.
Now, there have been some mediations which have taken more than that.
Yeah.
And, we have to go back to the court frequently and ask the court to extend the time. And court has been very generous in granting time.
Yeah. Yeah.
And one matter which we were doing, a cross-border mediation, it took almost 6 months to settle it. But it got settled ultimately. Now, what if we say that, strictly follow the 90-day period and say that, hey, 90 days is over, sorry, we can't do the mediation anymore. Then the parties would not have had the opportunity of settling. So
Yeah.
my question is, why do you impose a time limit at all, given the fact that it's a voluntary process?
Uh,
Jawad,
Yes.
while we are on this topic of pre-litigation mediation, there's a general feeling that we've possibly missed including, pre-litigation mediation as a major part of the act. In countries like Italy and Turkey, we have the carrot and stick policy with regard to pre-litigation mediation. What are your thoughts on it?
See, there was mandatory pre-litigation mediation under the draft bill. But what happened was there was a lot of objection from lawyers' bodies, the Bar Council including, saying that it will be amounting to denial of access to justice. Now, my question is, when you have 50 million cases pending, which is 5 crore cases pending, you have already denied justice, right? You have already denied access to justice. Now, at least if you make mediation mandatory, those cases that go for mediation mandatorily, for all you know, people may not know about mediation. So when they go for mediation, they realize that, hey, this is a good process, so let's settle it here. And if they settle it, you're actually opening up the courts to be able to do justice to the people who really deserve justice, where the courts really need to intervene and do justice, right? So actually what you have done by taking away the mandatory pre-litigation mediation aspect of the act is that you have denied access to justice to the people of India. So that is what I believe in. Now, what is happening in, if you see outside in countries like Italy, they have what is called as the opt-out model. So people have to mandatorily go for at least one session of mediation. Now, the draft bill suggested 2 sessions of mediation, but in the Italian model, it is 1 session of mediation. Now, they find that more than 70 to 80% of the cases are getting settled in mediation. So though parties go for mediation because there is a mandate to go, but once they go there, they realize the value of finding a settlement through mediation instead of going to court. So it all depends on the effectiveness of the mediator, right?
Yes, can I ask?
Yeah.
Go
Yeah,
ahead.
but
Yes.
what I want to ask you is that regarding consumer courts, because when we have the court annexed mediation, like in Supreme Court and other courts, so there is no fee charged otherwise. But in consumer courts, that they are charging, and according to their rules, they are charging to the litigants and asking them that if they want litigation, they have to pay this much. So this is not pre-litigation, during the litigation. So is that valid, or what do you have to say about it?
No, in my opinion, I think courts should start imposing a fee on the litigants when they refer the cases for mediation. Because then what will happen is, if you're going to be continuing to have it as a pro bono affair, then you're defeating the purpose of pre-litigation mediation. So what happens is, there was somebody who called me and said that we want, in a matrimonial matter, we want some mediation to be done. And I just asked the names of the parties to rule out any conflict of interest. Then they said, what is the fee? And I told my fee. And then I heard nothing from them. And 3 months later, that case gets referred to mediation to me through the court. So apparently what the lawyer has done is, hey, look, let's go to the court and get it done free of cost. So I don't think this pro bono affair should continue anymore. Of course, in deserving cases where people really, cannot afford to pay, it's a different matter. But in cases where parties can afford to pay, because they're gaining a whole lot by settling through mediation, they're saving a lot of money. So why not pay the poor mediators also?
No, that is okay for the commercial courts. I do agree they should be, but then consumer courts, because there are petty matters also. So in consumer courts, putting a fee, because that is an area where mediation can do really wonders.
Yes.
But there we are not getting any mediations, only because clients are not opting for the mediation. They don't want to give any other fees.
In fact, Jawad, to continue this conversation, I was just wondering whether, this fees that is not being charged is only till it really takes off, the mediation movement, because till now it's still at the nascent stages, and you will find advocates and clients not really wanting to go in for mediation. So maybe till it really takes off, they need to have some kind of an impetus for it and not charging. Maybe what they could do instead is have a limit below which, like you have for legal aid, that legal aid will not be given for amounts more than X.
Yeah.
Maybe you could do the same for this. But yes, some of them could be free if the amount involved is below a certain threshold amount. What do you
No,
think
that's
about
a
it?
good
That-
idea actually, Shireen, because you can prescribe a threshold below which
Right,
there will be no fee.
right,
The
Yeah.
court will pay an honorarium to the mediator. Above that, I think the
right,
court should fix the fee.
right,
Because,
right.
after all, if the mediator is putting in a lot of time and effort in doing it,
That's true. No, your case is a
and
classic example of, how it is misused, so to say,
no, that's
so
okay. But what I'm trying to say here is this, that, if you really want to professionalize,
that's true.
then there has to be a value attached to the service, right?
Right,
If
right,
it continues to be pro bono, there's no commitment. There's no,
right,
not many people are really passionate enough to do it pro bono always.
right, right.
Sir, I have a
Jawad,
question here. Sorry, ma'am.
right,
Just one thing, as you
right,
said, in the Mediation Act says it is voluntary. The mediation is not compulsory, right? As per the Mediation Act 2023. But
Yeah.
as per coming to again to the Commercial Court Act, it says it is compulsory. So pre-litigation mediation, you have to go, one party has to go to the mediation, and then it is voluntary for the second party, whether it is his choice, whether he is attending the mediation or not. But for the first party, it is mandatory to go as per Commercial Court Act. So in this scenario, can you just clarify a little bit? It is mandatory or voluntary in the sense of Mediation Act and the Commercial Court Act?
See, under the Commercial Courts Act, as you rightly said, Vinita, it is mandatory, right? You have to go
Yes.
for mediation. There was a recent Supreme Court judgment also.
Judgment
said
also.
You have to go for mediation. Okay.
Yes, sir.
Now, Mediation Act doesn't say that it is mandatory, because in other matters which do not come under the purview of the Commercial Courts Act, it is your choice. You want to go for mediation, you go for mediation. If not, you go to the court directly. So that is the distinction there. Of course, there are a lot of anomalies surrounding the working of the Commercial Courts Act and the Mediation Act.
Yes,
So
sir.
those anomalies will have to be sorted out by either the courts when they get to deal with these matters, like what happened in Afghan's case, where Section 89 was
Yes.
clarified substantially. So something like that has to happen. Or the legislature should say that, okay, look, we made a mistake. We should not have done this. So let's correct ourselves and carry out the corrections in the act by making the necessary amendments.
Yes, sir.
Jawad, before we just move on to the questions which are there in the chat box, I just had one question of you. The government is known to be the biggest litigator in India. What is the provisions? What are the provisions rather which are made under this act to take care of that, so that they can be a part of mediation? And what is the difference in the
Earlier,
existing?
under the first schedule, the government disputes are totally excluded. But that has been done away with now, and commercial disputes involving the government are still, capable of being mediated. That provision is there already in the act. I'm not able to, I'll need to check the act for that.
Right.
But they can be mediated. So therefore, there is a scope for mediating commercial disputes involving the government.
Right, but what is the impetus given? Because normally what happens with the government is they are a little concerned about entering into a settlement, especially when there is money involved, saying there may be an allegation against them for some kind of a corruption. So could there be a special body which is set up, by the government for each of their departments, which is going to deal with the mediated settlements? It could go over to a body rather than to an individual, and they could take a call on it, whether it should be settled or not. Is there any
Yeah, I
such
think that
provision?
is something, that is an initiative that the government will have to take on its own. Because
There's nothing in the act as of now
nothing
which
in the
really
act as of
assists
now,
them.
yeah, there's nothing in the act as of now to do that. So, for example, if you take the US, a lot of federal statutes which involve the government, like for example, the US Postal Department, they have a mandatory mediation provision.
Right.
Now, one of the biggest challenges, as you rightly said, is that, the accountability. Because supposing I'm a government official and I enter into a mediated settlement agreement, tomorrow I
Right.
should not be called into question in some internal audit or some other process where they say that, why did you agree for this? So I think in one of his articles, Mr. Sriram Panchu, or somewhere where he spoke, I heard him saying that there has to be some mechanism that the government has to evolve, where if an agreement is reached by a government official with regard to a dispute in which the government is involved, that should go to some high power committee for vetting, and they should give they should give their opinion. And after that, there should be immunity for the official from any further questioning on that part. So I think there has to be some mechanism that the government needs to put in place to encourage the resolution of government disputes through mediation. Because merely having a provision under the Mediation Act saying that government disputes involving of a commercial nature can be mediated will not be sufficient to really promote mediation.
Exactly.
So
It
as you
doesn't
said,
have any meaning.
Yeah,
Right.
absolutely no meaning at all for that. So it has to be
Right.
backed up with something more. So
Right.
that comes, hopefully that should come.
If I could just read out some of the comments which are there. Gaurav
Just
Kohli.
1 minute before that, I think Deepika
Sure.
has her hand up.
Please, sir.
Is it? I missed you. Hi,
Very
Deepika.
good session. I first of all, I congratulate Shireen and Mr. Jawad. I just want to, you being the expert on this topic. So what steps could be taken by the mediators itself for awareness of this mediation among the community, not among the lawyers? I am asking specifically so that more and more persons should know the value of this aspect, that mediation is very beneficial for them instead of adjudication.
No, I think that awareness we all have to keep spreading at different levels, Deepika, because wherever you get the opportunity to speak and talk about mediation, which is what I keep doing. Like I was in Colombo recently, and in a panel discussion, a question was put to me that why would people incur some additional cost by going for mediation when they know that there is a possibility that it might fail? So my retort for that was, if supposing you have a disease, a problem, a health issue, and there are two options before you. One is there's a possibility you may get cured through medication, or the other option is a drastic approach like a surgery. Which would you prefer to do? So it's as simple as that, So basically, we have to create that awareness among people. See, we are quite an argumentative people, and we have imbibed this British system so deeply into us that the only way we can think of is, I'll see you in the court. So we have to change that and say that, let me see you on the mediation table, right? Let's talk about it. Let's discuss this. So it's a simple way of approaching a conflict. Okay, if you have a conflict, what would you do? If you have a disease, what would you do? So conflict is like a disease. So if you manage it, if you control it, if you're able to, overcome it, well and good. If not, you go for surgery. Surgery is always an option for you, right? But try this first. Why not try this before you actually go for a drastic option? So we need to bring about a cultural paradigm shift in the way we think of our approach to conflict. So
and I think, as you said, as you rightly said, it's by more conversations, including like today and your Colombo ones. And, the more we talk about it, the more the awareness will spread. And I guess that's what we mediators need to do. The oftener, the better that it is.
So we need OPDs.
Yes.
Instead
right, Deepika. Thank you, Deepika. Sir, if I could just read out some of the comments. Gaurav Kohli says, as at the district court, we are already mediating criminal and domestic violence except sexual offences since 2010. He says, since when I joined, which is true. I think that most of the matters, criminal matters, could be mediated, except some of them which were not really compoundable.
Yeah.
Am I correct on that?
Yeah, that's correct.
Okay, then
but today, the thing is, the world hopefully should be moving from retributive justice to restorative justice.
Right.
See, what we have done is we have, defined certain things as offenses. Like, for example, if you take homosexuality, it was deemed to be an offense at one point of time, right? But with the change of culture, with the world undergoing a lot of transformation in terms of the way we think, that is no longer an offense. So there are things like this that, we need to really think about, where these things don't really cause harm to anybody, or even where they cause harm. See, I always give this example of the case I read about in Canada, where this teenager committed a hate crime, and the court ordered mediation between the two mothers. And the two mothers came together and decided that they will give this boy a very good childhood, so that a very good upbringing, so that he comes out of this spiral of violence and crime that he had got into because of his background. See, criminals are made by society most of the time. A lot of deprivation, a lot of violence that they see during the childhood. Now, why can't these cases be, mediated and solutions sought to be found? Where the focus is more on the reformation of the criminal rather than punishing them. It's not every case that really demands a punishment. There are heinous cases where the conscience of society is shocked. But there are other cases where sometimes you feel really sorry for the criminal himself.
Seem to have lost you. No? Okay. Okay, I get you.
Yeah.
Thanks. Mridul Agarwal says that, as you rightly said, mediation is the medicine before the surgery. Gaurav also says, Jawadji, when all mediators are doing a wonderful job by reducing the number of cases and saving lakhs of hours of the judiciary at the district court and the various courts, why not to incentivize them by bringing them into the judiciary at the district court, high court, and Supreme Court levels? There must be some quota or reservations for meritorious mediators who are performing well to bring them into the judiciary. And he says, I want all hosts to put in their views on this, just like senior advocates are given priority in appointing them as high court judges.
No, but my question to Gaurav is that, don't you see a difference between a role that a judge plays and a role that a mediator plays?
That's
If
true.
you're going to be a part of the judiciary, then you cannot be a mediator anymore.
Sir, but if you want to reduce the number of litigations, as you said yourself, that 50 million cases are pending over there. So if new judges will be recruited from the mediator cadres, don't you think that this number will drastically reduce to a very extent, to a very large level? This will be reduced. If I am not wrong, then
why should you recruit from mediators? Why can't you
so that
recruit lawyers?
because judges bent of mind is only on judicial aspect, whereas certain matters
Gaurav,
which are.
Gaurav, to add to what you're saying, actually, these days there's a lot of training which goes on a continuous basis on mediation for existing judges. So maybe that would take care of your concern, that the
But ma'am,
judges
despite
are.
of that, if you will see their records, at district judges or at high court, the mediators who are advocates and the mediators who are judges, there is drastic difference between the number of cases solved by them and solved by advocates, because their bent of mind is totally a different level. And the person who are only mediating, that means those who are not judges, since they are when they started the career. So it's totally different. The approach is different, attitude is different, and certain other things are there which inculcate makes a good mediator. So if mediators will be appointed as judges, I think that the number of litigation will be reduced to a very great level, and
So
judiciary
I
as well
think,
as.
right. So I think everybody would agree that the mediators who've become judges are doing extremely well in settling cases. But the other point I think still remains that let the existing judges be trained in mediation specifically without necessarily being practicing mediators, which is what is happening just now also. Pooja says that my other observation with regard to the lack of Singapore Convention was mentioned, but then Shireen took over. I'm sorry for that, Pooja. Over to you. You want to talk about it? Pooja? You wanted to talk about the Singapore Convention or the lack of the Singapore Convention in the present act.
Just a second, Shireen.
Yeah.
No,
Yeah.
that was, you have to take over because you were conducting that. So I just was mentioning it so that you could take
Don't
over.
worry.
That the
Tell me.
lack of Singapore Convention somewhere holds back in we are looking towards India as a hub of international mediation. If that be so, as a hub of ADR, then how do we cover up this lacuna with the lack of Singapore Convention being mentioned in the act?
Yeah, I think I don't know what exactly the plan of the government is, whether they want to have a separate, perhaps some kind of a law that deals with the Singapore Convention. I don't know what exactly it is. But one would have expected them to include the Singapore Convention under this act itself, because the very purpose why the act was needed, one of the main reasons, the requirement for the act is that to give ratification to the Singapore Convention. But that has not happened. As a matter of fact, the act is counterproductive in that sense, because by conferring the status of a decree of court on an international mediated settlement agreement, it virtually takes that out of the purview of the Singapore Convention. So that is one drawback. The other drawback is that it talks about international commercial mediation alone. Now, what happens to international mediation? Because that doesn't come under the Singapore Convention. Disputes like family disputes, custodial disputes for children, disputes where people are abroad and, the other family members are here, and there might be a dispute between them with regard to so many factors like division of property, even matrimonial matters. Now, what happens to those kind of disputes? Whether those mediations can really does the act recognize those mediations? What is the status of those mediations? At least there, the act should have, spoken something about it. So the act is completely vague on that, and there's no, in fact, it excludes those mediations completely from the purview of the mediation. So this is one of the biggest challenges that we will be facing in the future whenever we have disputes where we are trying to mediate between, let's say, a couple who's fighting over the custody of the child. Both are situated, one is situated in India and another is abroad. Now, under which category does that mediation come under? Because Singapore Convention doesn't cover it, Act doesn't cover it. So where does it go? So these are all the lacunae that are there in the Act.
I think it would possibly need a new act itself, because now it would be possibly very difficult to really get it in over here. Okay.
So there can't be multiple acts. I think this act itself will have to
amendment. Have a
Yeah.
chapter included in it.
Yes.
And maybe some
Just
alterations.
add to that, like you've been USA, from where we've just started with the training process and everywhere. There is no specific act per se with regards to mediation, and they've been doing it successfully over the years. So wouldn't it have been easier just to ratify the Singapore Convention and continue as it is? Because we've been mediating since, I think, 2009. My first mediation training was in 2006 from Dallas. And since 2009, I'm on the Supreme Court panel, High Court, we've been doing it, Saket, and there's so many others like here. For instance, Jawad sir, you started in 2006. Without the Mediation Act also, we were doing it. Wouldn't it have been better if the government had just ratified the Singapore Convention and allow us to continue as it is?
But I think, Pooja, now it's not done. So we'll have to find ways of dealing with it now. So
we are on an observation. We are on an observation. So that is the observation which I have, and which I'm asking from Jawad sir. What is your take on that?
No, I feel that, it is a good thing that we have a separate act for mediation. There were different options available at that point of time. Either the Arbitration Conciliation Act could have been amended. So many things could have been done. But today we have an independent act, and it's a good thing that we have an act. The only thing is there are loopholes in the act. Unfortunately, we don't have the quality of legislatures that we used to have before. There's a lot of defects in the drafting of the act. So, but over a period of time, hopefully that will work out. So we can expect as the act comes into effect and really starts working out, then all these things will come up. And ultimately, the government will realize that, okay, this is what we need to do, and we need to make these changes, and they may bring about those changes. So let's hope for the best. We have the act now, let's live with it.
Thankachan says, I believe no service is to be free, including mediation. Only then can we provide quality of service, which I think we all agree with. Gaurav says, fees should not be uniform because they are very creative and articulate persons. I totally second him, who perform their role as mediators very well. So they must be categorized based on certain parameters and be divided into categories. I think that's well taken, the point. Thankachan says what I think you had mentioned, Jawad, that the time limit should be flexible. And Gaurav agrees with him. Thankachan also says in some cases we might need more time, especially in partition matters. If the cost of litigation to the litigant will be reduced due to mediation, then it will definitely increase. Litigation manifold will be win-win situation for the advocates too, says Gaurav. Thankachan says, as we are mediators, there may be flexibility in the charging fees itself. It stands on a different footing than the profession. And in deserving matters, of course, we should do it pro bono. Only compoundable offenses are mediated, is one of the observations. Thankachan says we need more primary health centers than super specialty hospitals. That's in continuation of your remarks. Totally right. Raki says mediation is a successful treatment without the surgery, I think. It is advisable to give mediation training to the judges, but they should not mediate. That is true. In the court, I think, Jawad, what's your take on that? In the court, should the judges be mediating while sitting there as a judge?
I don't think so. See, one of the cardinal ethical principles of mediation is self-determination. See, it should be a decision of the parties. So even if a mediator makes a suggestion, it is only a suggestion, it's not a direction to the parties to accept that. It's something, it's an option the parties can consider. Now, for that, the mediator has to be somebody who's not a judge. Because when you carry that authority as a judge, automatically what happens is the parties feel obliged to do something because the judge is asking you to do, or the judge is basically because he or she is the judge, they expect that there's a deference to the authority, and therefore they feel that if the judge says something, we have to follow it and we have to listen. So it takes away that element of self-determination from the mediation. And judges are trained for a particular job. Let them do that job. Okay, let us not burden them additionally with mediations also, because as such they are overburdened. Okay, so let them carry on their job and let us do our job and make their job a little easy for them. So that, what we need to do, we need to look at is, apart from the fact that the cases need disposal, for which the court annexed mediation program is there, increase the number of courts, all those policy decisions which possibly the governments and the courts can take. But what we need to do is we need to plug the inflow, and that is where pre-litigation mediation could be an effective tool of plugging the inflow of cases.
Right.
Because Niti Aayog says that it will take 326 years for us to dispose of the pending cases. So, but for that, we need to plug the inflow. So imagine that, if cases are coming to the court, let us say that 50% of cases that are capable of being settled, let's say 50% need really the adjudication by the courts. Why not try to, block those 50% from reaching the courts? So that is what we should be thinking about, rather than discussing anything else.
Monica says that the requirement is to change the bent of mind with sensitizing all about the mediation. I think we all agree with her on that. Pooja says, thank you for the wonderful interactive session, Jawad. Sally Thomas says, where the minor's interest is involved in mediation in terms of money, don't you think it's better for the party to get a sanction from the court that the minor's interest is well protected? I think that is true.
Absolutely right.
Jawad, thank you so much on behalf of Nivaaran and all the participants for being with us today at the beginning of the year and the beginning of a new era. We've, I think, all benefited from your, experience of it. We've got a more lucid understanding of the new act, and you have shown us the opportunities which are available under the new act. So that it's not just that the courts are not overburdened, but I think it is also the litigants and the advocates who realize the potential for it. Thank you so much for that. And on behalf of Nivaaran and the Supreme Court mediators, I would also like to thank the participants, because it's because of you that it has become a more interesting session. Thank you so much. We look forward to
Thank you
meeting
very much,
again.
Shireen, and thank you, Nivaaran, and especially the participants, all my friends who are here.
Thank you, Jawad sir, and thank you, everyone. Thank you.
It was a wonderful session.
Thank you very much. Thank you, Santan.
For your time.
Thank you,
Jawad sir.
Thank you.
Thank you.
Thank you.
Thank you, everyone.
Thank
Thank
you.
Thank
you.
you, Shireen. You have
Thank
conducted
you.
the entire thing very well.
Thank you so much.
Mr.
Thank you,
Vijay Kumar.
Santan sir. Thank you, Jitendra sir. Thank you, Jawad, of course. Thank you, Jamshed, for being here.
Thank you.
And thank you, Rakhi, for being here. Thank you, Vinita. Thank you, each one of you, for being here. Bye-bye.